This is Musings and Counsel from London Baker Law with Debbie London Baker.
We just got another text from a listener. I'm really enjoying your show. What if the person who has power of attorney passes away suddenly?
Good question. Okay. So here's what I recommend. It's not required by law. I recommend, two things. One, if you have a power of attorney and that person has passed away, go get yourself a new power of attorney right away. I mean, go call whoever created the first document and get a new one. I always recommend that, let's just say I have Steve as my power of attorney. Okay. And Steve and Sophia have been my friends forever. Okay. And Steve is my primary power of attorney. I always recommend a backup. Now, it doesn't have to be Sophia, but I always recommend having somebody already in place to take over that role if something happens to Steve, whether he's passed away or he's busy having surgery for something and he's in no position to do anything for me, for the next 6 weeks or something. Because then the document will say, in the event Steve is no longer able or willing to hold this role, then I appoint so-and-so as my successor. But you've got the document in place. I have a mentor that I've been working with for a long time, and I used to be adamant about people having successors. And she finally said, get off of their case, Deb. If something happens to the person they know, they'll call you back and you'll name somebody new. And I went, okay. So when people say, well, I don't know anybody,
That's a great idea. I didn't even know you could do that. Have a backup.
Oh, yes. And there are people who do more than one. So I've got clients like who do their spouse, and then they do their eldest child, and then they do their younger child. So it's just all there in the document. But for the person who wrote it, if that power of attorney has died suddenly, tragically, whatever, just call whoever did that original document for you and appoint another person. And if you have somebody to back up that person, do that at the same time. Your power now in Florida, you have to appoint an agent. That's what they call him, that you trust completely, because that power of attorney in Florida goes into effect the minute you sign it. Other states have different formats, and the powers of attorney don't go into effect until you become incapacitated as determined by doctors, I guess. But in Florida, it goes into effect immediately. So you really want to trust that person having access to your financial information completely, that they're not going to do anything nefarious, anything underhanded, anything that will hurt you in any way. And sometimes people will say, I wouldn't trust my daughter with $50. I'm not giving her this power. Good. Don't give her this power. Very smart. Very smart. Hope that answers the question.
This has been Musings and Counsel from London Baker Law. Learn more at londonbakerlaw.com. Thanks for listening.